I'm Larry Mathis. I work out of the HR department. I really want to thank you for coming in early so that we can get the registration process seamless. We've had issues with it because people came just before 9, and so we will still be registering. But some of you are here as early as 8ish, and so we're in and we're ready to go. A few housekeeping things. The restrooms are out the door to the left or right. Follow your nose. You'll see the signs. There will be a knowledge test after the experience, which you can do online, or I have hard copies. If you're going to do it online, on your handout, we have the URL by which you can go and do the knowledge test. Is there anything you need before I introduce our presenter for today? Our presenter today is an outreach and education coordinator for Colorado Civil Rights Division, where she educates employers, interested groups, and individuals throughout this state around anti-discrimination sections of Colorado law. Received a law degree from St. Louis University School of Law. She is a former commissioner of the Denver Urban Renewal, former member of the Stapleton's Development Corporation, former president of Lower Downtown Residents Organization. She served on the board of the Planning, Preservation, Zoning, and Design Task Force for the Mayor of Denver. Please give a royal welcome to Frances McDonald.
Thank you, thank you, thank you. Thanks, everybody. I am pleased to be here again, and we briefly went over what you've got in front of you, and for those of you who weren't here, please look at 2 sheets of paper. One's 8.5 by 14, and one's a little packet. The 8.5 by 14 is to be posted in every employer, apartment, dwelling place, or public accommodation, bar, or restaurant. And it is important because it's a good thumbnail of the anti-discrimination statutes in the state of Colorado. It's also up to date. It doesn't have in it certain items that were signed into law by the governor in the first week of May. So this is an up-to-date piece. You'll see at the bottom right, it has 12/12, and the important part about that is it has the new website and the new phone numbers and so forth. The pre-employment inquiries you might like, or you might want to give to a friend, that have pieces that if you're a manager you might want to look at to see what's a yes and what's a no in the state of Colorado, which works very much with the federal government, although this is not the federal government. And in preparation for interviews, you might want to use this. If you're a person who is being interviewed, you might want to use this after you take some notes. What we're going to do is about an hour and a half presentation, and I'm going to be talking mostly. You certainly may interrupt and ask a question if you would like. However, I would ask that you'd hold, because of the numbers, I'd ask that you'd hold the questions. I'll be around afterwards and answer anything specifically. In the front row here, next to Dr. Mathis, is John Wilson, who is the State of Colorado Civil Rights Division intake supervisor. So if you had a question about an intake issue, a term of art that means how do you get your charge filed, you might ask John for a question. Jennifer McPherson is to the right of, or to my right, to John's left, and Jennifer is the manager of the Fair Housing Division of the Civil Rights Division. I'm going to be talking mostly today about employment, which is the top line of the arrow. Jennifer is the second line, the second bullet, and Jennifer can also visit with anyone about public accommodations if they have a question. The piece is presently being filmed, am I correct? And we're just going to start with the 8.5 by 11 multi-sheet copy, and it should start, the first page is what is up here, and there are little note slides on the side for you to take notes. So we'll move on through. We'll talk about the civil rights statutes in the state of Colorado. We'll talk about what the statutes mean, and then we'll talk about what you can do if you feel as if your civil rights have been violated. Today we're talking about anti-discrimination in employment. And the first thing to do is to look at the mission of the organization. And the Civil Rights Division's charged with the enforcement of the state's civil rights statutes. Our offices are at 15th and Lincoln, catty corner from the state capitol. So we are right there to make input and to hear answers or hear questions regarding the state civil rights statutes. The Division of Civil Rights is in the Department of Regulatory Agencies of the state. We're in the DORA department. The mission of the civil rights area is to protect businesses and consumers from the damages of discrimination. It's statutory. Employment 101 is the name of this class. We're going to be talking about, in the statute books, Title 24, Chapter 34, and Parts 3 through 7, which talk about the statutes regarding discrimination having to do with employment, housing, and public accommodations. The time limits for which you can file the discrimination charges on employment, housing, and public accommodations are noted here. The one that I would particularly point to is public accommodations. If you believe, after you take this class and after you do a little reading, that you or your friend has a charge of some sort that they want to file regarding civil rights and having to do with public accommodations, note that the time limit is very short, very, very short. It's 60 days as compared to the 1 year for housing and the 6 months for employment. So if you have a question about public accommodations, get right on the issue and see what kind of an answer you have. The statutes that affect the state of Colorado, down at the state capitol, from the state capitol, at Colfax and Lincoln, are effective of all employees for a state's employer. Doesn't matter how many people work for the state, it affects all of those people. If you were a federal employee law, if you were going to claim that a federal law had been broken, an employer that has more than 15 employees may have a complaint filed against that person. If there's an age discrimination case that's federal, the employer has to have 20. So there's some pretty sort of beginning charges that you file there. The charges are filed with the Equal Employment Opportunity Commission, and it's a very simple, straightforward way to look the federal charges up on the internet by just going on Google and pushing in EEOC. In Colorado, and federally, but in Colorado particularly, which is what we're talking about today, the civil rights laws were written by the legislature in order to protect certain classes of people who had complained to the legislature. And those are called protected classes. So when you see that word, you're talking about, that phrase, you're talking about the classes of people that our legislature, since the late 1800s, haven't just been doing this in the last 50 years. Since the late 1800s, has been legislating are protected from discrimination. Now, we have easy to figure out what the protected classes are because they're going to be a list of them, and here's the list. The next thing to do is to figure out what discrimination means under the state of law in the state of Colorado and federally. If you wanted to look to see how the legislature was moving along as far as protecting classes, adding classes, you can go to the statutory citation 2434-402 down at the bottom there, and it'll be right on your website. You can get at it. That section 402 very simply and straightforwardly says what the legislature has determined at that time. There is a little change this year in statutory protected classes, and it will take effect at the end of the year, but it is age. Until the governor signed the bill on May 5th this year, age was protected in Colorado only through the age of 69. With federal, it was protected over the age of 40 and up. Colorado was over the age of 40 to 69. So 69 has been taken out, and we have it all the way up to the top, just like the federal organizations have. You see the protected classes, which are listed here. Race and color seem similar. The color was the first legislatively created protected class. Race was the second. Race was federal. And race would be in the early 60s. But color in Colorado was in the early 1900s. And the legislature just decided to keep both words. Same concept with national origin and ancestry. National origin came along federally in 1971, and the state decided to adopt that phrase. It had already used ancestry for many, many years. Disability is handled very much like the disability issues you would find with the state or with the federal government. So if you're interested in doing a little research, you can get on Google, do whatever you'd like there. Creed and religion are also a duplicative term, perhaps. Creed is the phrase that the state of Colorado used for many years, and religion came into the federal government use in the late 60s. Marriage to a coworker is Colorado protected class, not federal. Colorado. And the rule is that an employer cannot have a sign or rule that says you, an employee, may not be married or have a relationship or be engaged to a coworker. There are many exceptions to that, unless the coworker has to do with payroll, unless the coworker has to do with your supervision. So you will see when we get into, I'm going to describe each of these as we go along, you'll see when we get into it that you'll want to look if you have a question like that or a friend of yours has a question like that. You'll want to look at the statute and read it because once again, the language is very, very clear. You'll understand it with no problem. Within the last 4 years, sexual orientation, including transgender status in Colorado, was protected from discrimination in employment, housing, and at public accommodations. And we're going to talk about these in detail. That is not a federal statute, as marriage to a coworker is not a federal statute. Sex discrimination is also prohibited in the state of Colorado. Sex is also a protected class. So the main questions you're going to be looking at on these protected classes are what are they? But if you have a question or you're reading something in the newspaper, go to that statutory site because it's a very clearly written. You'll see that this presentation is as of today's date with the governor signing new statute or a new statute. It was a little bit safer to put the date of the presentation that we're doing today so that you'll know if you look at someone's old presentation, it is not effective on June 7th. So now we know what the protected classes are, what classes are protected from discrimination by the statute, by the legislature. We want to find out what discrimination means. And discrimination is a term that means it's treating people differently based on the person's protected class. You're not treating a person differently because of an unnamed reason. You're treating a person differently, and in this case, employment we're talking about, because of the person's protected class. You are not giving females raises, but you're giving males raises, and female is a protected class. You're not giving males raises, and you're giving females raises, and males sex is a protected class. Color, sexual orientation, and so forth. So this, if there's any point, not where you necessarily need to put a big X on the piece of paper, if you might need to just, if you're a manager, you need to fold down the piece of paper, this is what case law describes discrimination as. So when you're taking notes about your treatment of someone, or you're being treated by someone in a certain way, you might want to use these words. So now we've got the basics down, how to file a complaint. And John Wilson is the intake manager, and feel free to jump in anytime you want if you have an intake issue, and you may want to just not say anything because there are questions that may come up and we can get later. A person who has a complaint submits a complaint to the Civil Rights Division, and the Civil Rights Division, again, the addresses are on the back of this piece of paper. They're also on the back of your handouts. And they talk to one of the people that John supervises, an intake specialist. And that person, the intake specialist, takes the data, the information that the person has given them, and translates it into a form so that all the proper statutory pieces are met. The charging party says the name of the person or entity who has to respond to the charge. And because they're responding, that person's called the respondent. Witnesses come in. Pieces of paper, often nowadays emails come in as exhibits. The intake staff, John's person that John has supervised, John Wilson has supervised, asks first, is the person who's filing the charge a member of the protected class that is protected in that complaint? And the protected classes, again, are the 3 bullets: employment, housing, and public accommodation, show the list of the present protected classes there. The Civil Rights Division, CCRD, is a neutral agency. It doesn't do an advocacy for one party or the other. It investigates charges. If you want to have an attorney and you filed a charge, or if you're an employer or respondent and want to have an attorney, you may obtain one. However, that is not part of what the state does. That is your responsibility. When a charge is filed, the first thing that has happened, and this is in the last several years has become way more popular than it has in the past, because alternative dispute resolution can be handled immediately upon filing of a charge, and it can be handled before the approximately year-long investigation goes into place. So if you wish to file a charge and have it mediated, if you're the charging party, or if you're the respondent, the employer, the Civil Rights Division will call you, phone you, and say, would you like to have us attempt to negotiate a settlement between the two? And many places now say yes, people say yes. And it can solve the, while you're in one office and the other party's in the other office, and the professional from the Civil Rights Division goes back and forth and negotiates a settlement. It can be solved within a week or so, and perhaps within a month or two, as opposed to 12 months. Have a resolution that can provide monetary, non-monetary. Non-monetary would be move my office someplace else, or monetary would be you owe me this, you fired me improperly. If alternative dispute resolution does not take place, the party files a charge and the neutral investigation takes place. It's based, again, on the protected class. Evidence is gathered from the charging party, who has filled out with the intake person a full packet, the respondent, who files a thing called a position statement, and that would be you in HR, it would be you as many managers here. would file your position statement if anyone has filed a charge against you or your department. Third parties can also be interviewed, and there can be other documents that are gathered. After the documents come in, an investigation takes place by the Civil Rights Division. And in rebuttal, parties can supply additional witnesses if they want. An on-site investigation can occur through investigators, civil rights investigators, as opposed to the intake people, the investigators, who will go to the place of complaint, the respondent, and take a look at the charges that have been filed based on the protected class. If the division, if the Civil Rights Division doesn't complete this investigation within 180 days, 6 months, the person charging can request a right to sue. It's a formal term of a proposal from so that the person may file a lawsuit against the respondent. This is as opposed to the administrative agency which has done the investigation thus far, the Civil Rights Division. Under the law, the Civil Rights Division must provide that right to sue letter. After the investigation, the Civil Rights Director, Steve Chavez, makes a determination based upon the investigator's look at whether or not there is probable cause. A phrase, again, a term of art that is used. Is there probable cause to believe that discrimination has taken place? Or is there no probable cause to believe that discrimination has taken place? And approximately a year after the filing, this is with no civil lawsuit, the issue will be closed. If there's no probable cause for filing, the charging party can appeal to the Colorado Civil Rights Commission. And the commission is the 7-person organization that is above the Civil Rights Division, which is where I work, Jennifer works, and John works. And the Civil Rights Commission is a group made up of persons from around the state and representing the charging or the protected classes. And they meet once a month, and they will hear various civil rights issues having to do with statutory matters, but also they will listen to appeals of no probable cause findings. They'll uphold it. They'll return it to the Civil Rights Division for more investigation, or the commission will reverse the finding. If there is a no probable cause, the charging party can be advised of again, the term of art, right to sue within 90 days. After the whole process is complete, there is a shorthand for the word mediation, and that must, under law, take place, and it's called conciliation. So again, a year after it started, the charging party is in one area and the respondent is in another area, and the state of Colorado alternative dispute resolution person from the Civil Rights Division will negotiate to see if something can be gained through conciliation. If the charge doesn't settle in conciliation, there can be a public hearing before an administrative law judge, and the Civil Rights Division is represented by the Attorney General. There is, however, in the last month, the governor signed a bill adding to the remedies that may be gained if you have filed a Civil Rights Division charge in the state of Colorado, and if you have determined to move on to district court. Prior to now, you could be awarded back pay. You could be, someone could say to hire you. They could reinstate you. They could refer you to employment by somebody else. Now, the Job Protection and Civil Rights Enforcement Act of 2013 say that if the matter is taken to civil court, and then this is the key, so if you have to underline any words, please do this, and the plaintiff proves that he was the victim of intentional discrimination. That would be important for you all to know, intentional discrimination. Then there could be benefits that would be statutorily prescribed, and the statutory is in that statute number that you will see there. But they would also include attorney's fees and expenses. That has been something that has not been lacking, or has been lacking in the state of Colorado, and the governor determined to sign the bill. That will go into effect January 1 of 2015. Therefore, it is during this time that education of managers and HR departments to the change in the Colorado statute as far as remedies go is important to be getting out. It's not to be enforced right now, but the information regarding, particularly, I say as an experienced person, of attorney's fees and expenses is important. The Job Protection and Civil Rights Enforcement Act of 2013 don't make you as an employer subject to punitive damages if you can show that you tried to prevent unfair employment practices. And again, you might underline that because that would be data that you would keep in your notes. No punitives can be awarded for the failure to make a reasonable accommodation. This is disability. Regarding a disability, if a good faith effort, and that would be the underlined part, a good faith effort is shown to identify and make reasonable accommodation. Now, the statute in question is written, the number is written to the side of it. The verbiage in this slide is very much what the verbiage is in the statute itself that's within the last month. Again, January 2015 is the effective date. The 2015 allows education and outreach, and I think I would be called education, but there's going to be a lot more education regarding this statute, so that the statute really wants the education to be with regard to the protected classes, with regard to discrimination, with regard to harassment, with regard to what's already there. However, the point is to your friends and your colleagues and your co-workers, talk about it and read about it so that people that you know that are operational with businesses are up to date. So we talk about employment focusing today. And if anybody, by the way, would like to come down and use these big comfortable chairs and desks, I'm thank you for sitting on the floor. Please feel free to do that. So we're talking in employment today. Employment practices is what the new statute will update all of us on. It will be part 4. Employment discrimination, again, a definition, is a thing called an unfair employment practice. Case law and statutory law in many states and the federal government over the years say it's an unfair employment practice. Unfair, however, to me, is something different than unfair to you. So as a manager, we want to balance and watch very carefully what we're talking about. A policy that a corporation or an organization says is neutral on its face, we do not discriminate against any protected class, might still be discriminatory in its impact, as that final line says. If a female comes to a business and says, you don't hire enough females, well, we say, well, we do not discriminate, see here in our handbook. But the simple answer is a computer printout of who is employed by what. So the impact of discrimination can also be considered by you as you look at various places of employment. Some examples of discrimination are refusal to hire. I'm not going to hire, again, because of your protected class, because of your color. I'm going to fire you, again, because of your protected class, because you're female. I'm going to demote you. I'm going to pay you less because you're protected class. And those are fairly straightforward. The bottom two that I have separated are more complex and require more description. Retaliation is also an example of discrimination. And retaliation can be adverse action against a person because the person has filed a charge of discrimination, because of that filing of the charge. Or, again, in a department has opposed a discriminatory practice that's happening. Or, again, has testified against the person who has filed the charge. So you want to look at everything in retaliation in a much more big picture than a one-sentence guideline. Harassment is activity that's based on a person's protected class, the listing of the protected classes, which again are here on this 8.5 by 14 piece, that might create a hostile work environment. And once again, I'm afraid I have to describe what hostile work environment is, because it could mean some things to some people and some to others. But it's mostly a work environment that's offensive, disturbing, frightening, threatening. Tormenting behavior could happen. There are factors that you'll want to look at if you are a person who thinks that the person has been harassed, or if you're a manager listening to a person who's complaining about harassment. Because these 5 checkboxes are very much checkboxes at EEOC or at the Civil Rights Division. They're going to be asking you or the person, how often does it happen? Is it pervasive? Does it happen all the time? How severe is the conduct that the person's saying to you? Something that might be severe to me might not be severe to you. Those are the kinds of things that the investigator is going to look at. Does the conduct unreasonably interfere with an employee's work performance? And that's the one to put the star by, in my view. Ask yourself what this conduct was that the person is probably having a difficult time describing to you is, and if you can't pin it down, figure out whether, as the manager, it unreasonably interferes with the employee's work performance. When you get that, then go back up the list. The severity of the harassment has to be judged from the perspective of a reasonable person. Now, we're all reasonable, but we're reasonable in different ways. But the person has to be complaining from the perspective of the person considering all the relevant circumstances. This is not an all-purpose answer, but it is an understandable answer. You might have, for example, a female receptionist who has been with at the front desk of a lumberyard for 25 years, in a wheelchair for all 25 years. And the man that owns it has gotten along well with her and teased her and known her for 25 years and so forth. But he's getting ready to retire, so he pulls in a number 2 man. And this man is trying to get himself in good with everybody. So he starts teasing everybody. And one of the things he's doing is teasing the woman in the wheelchair. And it appears to her that he's teasing her because of her disability. So you go back to your harassment page and you see that that is the type of behavior that could be harassment. Then you see that you need to look at it from the complaining person's point of view. This is no more the days of, oh, he didn't mean that, or oh, she didn't mean that when she said that about your body part. No, this is the complaining person's point of view. So as a manager, you have to keep very good records of those complaining parties. So now we're going to talk about protected classes and specifics of protected classes. Again, if you found yourself on a PC or near a statute book, and mostly nowadays I think you'd really go into the PC, you can also go into, if you ever needed to look, go into the website of the Civil Rights Division, which is listed on the 8.5 by 14 and on your handout, and look up the website, and there is a rules section. There's a laws and rules section. So take a look at it if you ever need to. Again, we have the listing of the protected classes from 24, 34, 402. The first is age. House Bill 1136 from May 6 of 2013 raised the top in Colorado to 70, which is the same as the federal in the discrimination protected class. With protected classes, sex, an example, can be wage or hiring disparities, and that's simply a computer printout. Just print out how many people work in this department and what is required sex-wise and wage-wise. Sex discrimination includes pregnancy, which also includes medical conditions related to pregnancy, miscarriage, abortion, and so forth. And Larry, I would say that any questions having to do with pregnancy and on-the-job behavior come into HR. You are not, as managers, physicians. You provide a person with a job description, and the job description will have on it the essential duties of the job description. And that, as managers, you'll want to keep in mind, because you want to make sure that the people who take your jobs, apply for your jobs, are fit for your jobs. But if there's sex discrimination, if it's pregnancy discrimination, it would be considered sex discrimination. I would say that Larry would be a good place to go and ask questions. Would you? Okay. Sexual harassment falls under sex discrimination, and it can be defined as unwelcome sexual advances, requests for sexual favors, or remarks. It can be considered when the conduct says, you sleep with me or you don't get the promotion. You don't get the job unless you sleep with me. When the conduct interferes, just the same phrase we used earlier in harassment, when the conduct interferes with a person's work performance and can be considered intimidating and so on, it is considered harassment whether or not it results in a person losing a job or compensation. The latest in the sexual harassment issues are very important to pay attention to because of social media, because of sexting, because of iPads. This is something that I wouldn't have talked about a year ago because I didn't, well, maybe I was just too slow, but it is, sexual harassment can be considered jokes of a sexual nature, innuendo, language of a sexual nature. You could have a team of work people who went out with an iPad and determined to read magazines, inappropriate professional magazines at that point. That could be. And this is not me saying to you, I'm your lawyer, don't do it. This is me saying to you, I'm telling you as managers and as employees what could be considered sexual harassment. Sexual comments about a person's appearance or personal life can be considered sexual harassment. Display of suggestive materials can be consistent. That would be magazines. We don't see too much of that anymore. It's moved mostly to the internet and so forth. And remember, the internet belongs to Aurora. Sexual harassment, this is interesting, particularly for those of you in law enforcement, includes discrimination that comes from non-employees, including, but not limited to, vendors, customers, and clients. Vendor, you sit at the front desk, vendor comes in and is making very rude comments to whoever sits at the front desk. It is your job as the boss to see that that vendor stops doing that by being moved to another place to do it. Is not going to be your employee coming into your building, allowed into your building. Customers are people often, an easy example is customers sitting at a restaurant and the people at the restaurant table determined to harass or tease a waitress or a waiter. That may not happen, but that is one of the issues that the owner of the restaurant must take care of immediately by talking to you, the customer. It's a pervasive teasing type of complaint. Sexual harassment isn't limited to by male to female. It can be male to male, female to female. It's not limited to supervisors, to non-supervisors. It can be colleagues on both levels. As managers and as Aurora has planned and has a good section on sexual harassment in its manuals. So if you have any questions, look at the definition of it. It will be consistently applied by you as managers and you as employees. Go right to the HR people to make the complaint as quickly as possible. Take it away from your supervisor if you can. Make the policy known to all employees, which you've done. The employee, or the employer's responsibility, Larry's responsibility and the manager's responsibility is to take a thing they called the phrase prompt and remedial action with regard to complaints of discrimination. So keep track of when you get complaints, if you get them, and get them dealt with as quickly as you can. And show in the dealing with the complaint that you have the intent as a manager and as a corporate employee to a government employee to stop the sexual harassment. Remedial action can't be taken against the person complaining. He's being rude to me in a sexually explicit manner. It cannot be taken against him, so you transfer him to Burlington. The person complaining has to have the issue dealt with. Supervisors who are on notice of allegation must inform Larry immediately. That's your government policy, your corporate policy. It must happen. In the last 4 years, the state of Colorado has determined that the protected class will be those based on sexual orientation and transgender status. Sexual orientation would be heterosexuality, homosexuality, bisexuality, and transgender status is included. Transgender status has, again, on the website that you will see here, a brochure or a flyer if you wish to look at it and do some more research as to the status of that. You just want to ask yourself some questions as in a manager or as an employee. The first thing in the question and answer section regarding transgender status to understand is transgender means having a gender identity or a gender expression, two terms that have been identified, that's different than what the society expects based on the assignment at birth, and that would be the birth certificate. So you'll see at the bottom what gender identity is defined as and what gender expression is defined as. And you might want to just keep that page because we're going to move through a couple of frequently asked questions, and you might want to use those words as we get into it. So the state of Colorado has passed a a sexual orientation protection statute including transgender status. May employers enforce a dress code? Is a frequently asked question. Yes, you may. However, go to the bottom 3 lines and note that individuals must be allowed to dress and appear consistent with the individual's own gender identity. And right below that is the definition of what gender identity is, and if you're like me, you might want it on the previous page where it's printed bigger, and that shows you what gender identity is. Gender identity is the innate sense of the person's own gender, and innate would be the person's own sense of the person's own gender. So, in answer to the question of whether or not dress codes are allowable, yes, they are, but the person, the employee, must be allowed to dress based upon the person's gender that is consistent with the person's gender identity. So at some point, the person will change gender identities, and that is how the person must be allowed to dress. Dress codes are not too often discussed now. However, restrooms are. Must restrooms now be unisex? No, they don't have to be. But go to your bottom 3 lines. Individual allowed to access to gender segregated facilities have to be allowed based upon the person's gender identity. So the birth certificate says one thing, the person has made the transgender change, and the person's innate sense of the person's own gender has changed. And under the law in the state of Colorado, individuals must be allowed access to gender segregated facilities, this is men's or women's as opposed to the family rooms, that are appropriate to the person's gender identity. Moving now to a protected class, the protected class of disability. Disability works very much in line, as I said at the very beginning, with the federal organizations. Physical and mental impairments that substantially limit one or more of major life activities are a disability, are considered a disability. The Americans with Disabilities Act, Amendment Act, notes that, this is federal, that an impairment that substantially limits one or more of major life activities need not limit other major life activities. If you had a disability such as diabetes, you are still allowed to say that you have a disability. You are not limited by that. So what do you do when there's a charge of disability discrimination? When the person comes into John Wilson as an intake person, what happens? The intake person asks, is the complainant an individual with a disability? Did the complainant suffer some sort of adverse action, again, I emphasize, because of the protected class of disability? The third would be a phrase that you've heard used much, is the person who's complaining able to perform the essential duties of the job with or without a reasonable accommodation. Reasonable accommodation. So, is the manager able to have the job done with some sort of accommodation that's reasonable? So what's reasonable in accommodations that a manager might have if a person gets in a car accident or whatever, and they're a driver? They'd modify the accessibility. They'd send the person out in a non-stick shift car. They might restructure the job. They might take away the driving. They might reassign the person to a back office room till the broken leg was completely healed. That could be considered a reasonable accommodation. In order to interact, if you are the person who has the reasonable accommodation, the person who wants accommodation needs to go to the boss and say, this is what would be reasonable. It must be back and forth, so the employer and employee go into a discussion. And Larry, do you have people in your office integrate or interact with people concerning disability, reasonable accommodation? Oh, okay. The person who is attempting to have a reasonable accommodation should identify the limitations. So if you want a reasonable accommodation, do this, go through this list, identify what could be reasonable or unreasonable. And the employer is going to want to know, this is another phrase, if there is an undue hardship caused by your request. And that could be something along the lines of you drive a car and you've lost your sight for 6 months and you're saying, well, I can still drive the car. But the undue hardship for the employer might be insurance payments. The boss always, in all your job descriptions, is going to want to put, and you, if you're bosses, you are going to want to keep in mind what the essential functions of a job are. A person is supposed to or must be able to perform the essential functions without endangering the health and safety of others. So when you're assessing whether or not a person has a reasonable accommodation that is in fact reasonable, assess whether the essential functions, which you already have on your job description list, can be done without endangering a party. Marriage to a coworker is another Colorado-only statute. It is not federal statute. I've listed the statutory citation there and quoted the body of the statute, which is what we discussed at the very beginning of the class. It's discriminatory for an employer to fire someone or not hire them because the person is married or plans to marry someone. That's the statute. There are many exceptions, and I've listed two that are quite broad at the bottom. So if this issue is something you as a manager wish to deal with, or if you as want to advise one of your friends to take a look at the statute itself, and it should bring you to where you need to be. Religion and creed are protected classes in the state of Colorado. They're together defined as religious, moral, ethical belief, sincerely held, and include all aspects of religious practice. And notice that on the top I've got, this also may include political beliefs. Protected classes are also, as we discussed in the beginning, national origin and ancestry. And just like everything else, you're treating somebody different because of the protected class. You're treating somebody differently because he or she was born in a particular country or belongs to a particular national origin. Because of the accent, the ethnicity, or based on the country in which the ancestors were born. This class that you've had today is to remind you that it's the employer's responsibility to maintain a workplace free of discrimination and harassment. It's the employer's responsibility. It's an overview. It's not meant to be legal or managerial advice, but it is meant to give you hints. You've got my business cards out in the front. You've had a chance to meet Jennifer McPherson, manager of Fair Housing, and John Wilson, manager of the intake group. And please come up and ask us questions after we finish if you have any particular ones. I'm about to close up, but I'm going to ask you to, we'll wait a few minutes and ask a few questions afterwards if you'd like to just, if you could be thinking of stuff. I'm sort of going slowly while you think, if you'd like. You can see the Civil Rights Division's addresses and phones, website, and emails on that back page. Anybody over here have any questions that we can talk about? Anybody here? Anybody here? Sir?
Just a couple questions. First, a point of clarification. You said on the transgender status, you referenced that it was a law, but it mentions that is guided by a rule from the Colorado Civil Rights Commission. So is that a rule from the Civil Rights Commission, or is that a statute?
It's a statute.
It is a statute.
I'm sorry, I didn't. I'll look at that. I'll look at how I've got that. No, but check the rules too.
And secondly, what's the oversight on the CCRD itself, on the Civil Rights Division itself?
The Civil Rights Commission.
To ensure neutrality, that the Civil Rights Division is actually neutral.
Well, first of all, there is the mission of the organization that is assigned pretty carefully. But the Civil Rights Commission is I shouldn't say volunteer because they're paid a little bit to appear monthly, monitors the Civil Rights Division. Also, the statutory, and the Civil Rights Commission is responsible for the statutory legs of this, and that's what we'd see.
All right, so there is an oversight.
Oh, yeah, oh, yeah, oh, yeah. Anybody have anything else? Well, I thank you very much for your attendance. It was just I didn't do that to get me very much. And we're going to be sort of standing back here in this little nook to see if we can answer any personal questions that you might have. Thank you very much. We'll see you again in another month.
A couple of things. We have 2 weeks to complete the knowledge test. If you want to go online and do that, that's a part of your handout. If you want to do it paper and pencil, we have it here today. So is there anybody here that wants to do the knowledge test today, paper and pencil? If so, come down. Yeah.